Good morning, jury. On behalf of Ms. Reed and the defense's team, we want to thank you for your time and the diligence you have shown while listening to this case. I will now guide you through the charges, the evidence, and the jury's verdict form. And with a focus on reasonable doubts, in the end, you will have a specific guide to complete the jury's form, and we, the defense, believe it should declare Ms. Reed not guilty of all the charges. Here's why. So let's talk about burden of proof. It is the Commonwealth's full responsibility. It is on them. It is their burden to bring a case with enough evidence through witnesses, through facts, through documentation to show to the jury beyond a reasonable doubt that the charges alleged have occurred. We will address what reasonable doubt means shortly. I want to start talking about the investigation, which alone is a major cause for concern and left so many unanswered questions. Mr. O'Keefe was not only a respected police officer, but also known for taking in his sister's kids after her and their father passed away within a short period of time. We find that Mr. O'Keefe simply deserved better. This is a fallen police officer who, after a night of socializing with other officers and their families and friends, was found deceased in front of a house in the snow. The house, 34 Fairview Road, a home who used to belong to a former Boston police sergeant, Brian Albert. So how did the investigation start? The morning when Mr. O'Keefe was found. Who was there and what did they find? You heard from some of the Commonwealth's witnesses, including Lieutenant Paul Gallagher, who described the scene when he got there after a strong snowstorm all night. He took some photographs and statements. Why do I say Mr. O'Keefe deserved a better investigation? Well, let's see what he did. From the beginning of his testimony, as you may recall, he asked the neighbor for solo cups, where he collected blood he found around Mr. O'Keefe's body. He collected evidence using plastic solo cups. Solo cups people use for drinking beer. He did not have an evidence kit. He did not have gloves, bags, nothing special to collect evidence. This is known as contaminating evidence. He used a leaf blower to move the snow out of the way to look for further evidence. And what did he find? Throughout the case, we kept hearing about 47 pieces of taillights, a hat, shoes, and all kinds of evidence that the Commonwealth has presented was found at the scene. Did Mr. Gallagher testify to finding these? No. He looked through the snow, he used the leaf blower, but this is what he collected the day Mr. O'Keefe was found. Bloodstains in the snow and a glass, a drinking glass. Nothing else was found at the time Mr. O'Keefe's body was found. He did not take any pictures of the exact location Mr. O'Keefe was found. He did not interrogate any of the homeowners. He did not interrogate the people that were at the party the night before. He didn't go into the house to look for any evidence. He didn't look for any signs of struggle in the house. He didn't question a possible altercation, a fight. He didn't ask any of the neighbors for video footage. Well, the homeowner was a police officer too. You will hear from the text messages that were introduced in this case that the lead investigator, Michael Proctor, even made a comment to his friends that the Boston cop, the homeowner, is not going to catch any issues with this. So no pictures were taken of the exact location, right? And later, during a cross-examination, the Commonwealth asked our witness, Dr. Ranchler, you didn't know exactly where the body was, right? If you didn't know exactly where the body was, how could you calculate anything properly? Well, the investigators didn't document exactly where the body was. And this is on the Commonwealth. So here are a few pictures of the scene that morning and the bloodstains in the snow. Going back to the homeowner, Brian Albert, due to his relationship with another officer, Kevin Alberts, the Canton Police Department had to excuse themselves to avoid any appearance of impropriety. Mr. Brian Alberts, who was a sergeant at the time, was also a trained EMT. He was trained as a first responder, but he never walked out of the house. He didn't walk out of the house that morning when Mrs. McCabe and Karen Reed and Carrie Roberts were outside screaming, calling 911. They were calling 911 and trying to give Mr. O'Keefe CPR at the same time. And inside the house, there was a trained EMT who never walked outside. Even after the EMTs arrived, the police arrived, he never inquired. He was not curious. He did not provide any support. He simply didn't show any effort to help the fallen police officer that was deceased in front of his own house. So because of his position with the police department and his relationship with Kevin Albert, a member of the family, the Canton Police Department was excused and a lead investigator was assigned to the case. His name, Michael Proctor, Trooper Michael Proctor, who was later fired for his conduct during this case. You did not hear from Trooper Michael Proctor. It is important to note two things. Keeping in mind that the defense has no burden. The defense didn't have to stand up and speak at all. We are not required to prove anything to the jury. That is the Commonwealth's burden. So why didn't they call the witness that was the lead investigator in the case? What are they hiding? Well, at least the text messages that this lead investigator was sending during this time, that was presented to you. And we're going to go over them. We're going to go over them so that you can use them to weight the evidence being provided, to weight the testimony you have heard. You have heard from his supervisor, that is Trooper Yuri Buchanan. You might recall during his testimony, he said the investigation was conducted with honor and integrity, or anything that Michael Proctor had testified to or had it in a report, Mr. Trooper Buchanan would take it as gospel. So let's take a look at Michael Proctor's conduct during this investigation. This is a text message between Michael Proctor and his school friends, where he's telling them about this case he was just assigned to within 16 hours into the investigation. His friends say, "Oh, I'm sure the owner of the house will receive some shit." Michael Proctor says, "Nope, homeowner is a Boston cop too." What does that mean? Because of his position, he's not going to be in trouble. He's not going to be questioned. He's not going to be interrogated. Well, that's exactly what happened. He wasn't questioned. He wasn't investigated. One of his friends asks, "I thought he was drunk. Did he get beat up?" Michael Proctor responds, "Nope." Again, this is 16 hours into the investigation. What evidence besides the blood stains and a glass did the trooper have to confirm that there was no struggle? Did he question anybody? Did he see any footage? He would see his friend saying, "Gotcha, he was frozen in the driveway and she didn't see him." Michael Proctor says, "That's another animal we won't be able to prove." In his own text messages, the lead investigator is showing they don't have enough evidence. They're claiming one thing happened, one thing only happened, based on statements they heard from another witness, Ms. McCabe, and we will address them. Now, what else did they have to support this case? But still, knowing all this information, he says, we won't be able to prove it. And notice this. His friend says, "I assume you guys are out to make it cut and dry because it involves cops, right?" And somebody else says, "Something stinks." Michael Proctor confirms, "Yes, but there will be some serious charges brought on the girl." The girl, the outsider, not a member of the police department. The girl the lead investigator refers to here is the defendant, Ms. Reed, our client, a girl who was an outsider in this tight-knit group of Canton, Boston police officers and other federal agents. She was the outsider. And his friends ask what they believe is important at this time. Instead of focusing on the honor and the integrity that Mr. O'Keefe deserved during this investigation, they're talking about Ms. Reed's looks. They're objectifying her. Is she hot at least? She is a ... You can see it on the slide. Yeah, she's a babe with a weird Fall River accent, though. No S. Michael Proctor continues to provide his opinions. Zero chance she skates. She is ... This is the honor and the integrity that Trooper Buchanan was referring to. He's aware of these text messages. 3 days into the investigation, and the former Trooper Michael Proctor shares a picture of the defendant with his friends in a group chat. His friend asks, "Is that chick a smoke?" Michael Proctor responds, nutbag, as the chief would say, and continues to demean the defendant, talking about personal medical conditions. Honor and integrity. It continues on, as you can see in the slides. Now let's take a look at the text messages that Michael Proctor had within the police group, including his supervisor, who you heard from, Trooper Buchanan. Responding to a picture of the defense attorney Yannetti, a member of our team, David DeChico had sent to the former Trooper Michael Proctor, he says, "Funny, I'm going through his retarded client's phone. No nudes so far. I hate that man. I truly hate that man." Honor and integrity. No bias. Here, the former trooper shows the feeling he has towards a member of the defense team already in the beginning of this investigation. His job was to investigate all possibilities. His job was to look for all clues and see where the evidence would take him. But in the beginning, he already had his mind made up. He already had an impression of the defendant. He already had a very specific feeling for one of the members of the defense team. And Trooper Buchanan, his supervisor, came here and said, there were no bias. Everything was conducted with honor and integrity. Shortly, we're going to go over the possibility of collision, all the expert testimonies, and very importantly, the medical examiner finding the cause of death to be undetermined. So the Commonwealth is asking you, the jury, to find the defendant guilty of homicide for killing somebody. And the cause of death could have been homicide, but after the medical examiner examined the body, the injuries, she could not determine that. So her testimony alone is a reasonable doubt to you. Here's what the group text chat from the police said about this. David DeChico says, rookie move, not meeting with a medical examiner and getting that homicide determination. Michael Proctor says, Yuri and I had 2 conference calls with her, had numerous photos, etc. We laid out the entire case for her. David responds, should have had me or Jeff do it. Michael Proctor says, if you two did it, she would have made accidental or natural causes. Of course it's undetermined. She was a whack job. Dear God, WTF, what the hell is inconclusive about the whole thing? Who's Michael Proctor referring to here as a whack job? Again, just words he apparently likes to throw around. He called the defendant that, and now he's talking about the medical examiner using the same terms. Is this honor and integrity? That is what Trooper Buchanan testified to you, the jury. This is what I want to remind you of, that you, the jurors, are the ultimate arbiters of witness testimony. You get to decide which witness to believe in and how much weight to give to their testimony. So when Trooper Buchanan testified in front of you that this investigation had no bias, was conducted with integrity, you get to believe that or not. You get to decide what weight you're going to give to his testimony based on all the facts being presented. So what else did the investigation fail to show? We will outline a few examples here supporting our previous statement that Mr. O'Keefe simply deserved better. The Commonwealth alleges that Ms. Reed dropped off Mr. O'Keefe, reversed her SUV, hit him with intention, left him in the snow around 12:32 a.m. Well, there are a lot of reasons why that is not possible. We will talk about the reasons why the collision is not consistent with his injuries. We will talk about the fact that Ms. Reed connected her cell phone to Wi-Fi to Mr. O'Keefe's home at 12:36 a.m. And it was just simply not possible to drive from 34 Fairview to Mr. O'Keefe's house within that short period of time, especially during a strong snowstorm that was even on the news. But not only that, as you heard testimony from the plow driver, Lucky, who came here and showed you guys his Frankenstein truck, a big truck with lights everywhere that he uses to plow when there is snow. He testified that not only he drove by 34 Fairview at 2:30 a.m. and did not see a body in the snow, but he also was familiar with the house. He knew the people who lived there. He previously delivered pizzas there almost every Sunday. So it was normal for him, as any of us, when we know someone, to look at their house and maybe think, oh, that's where so-and-so lives. So Lucky was plowing through 34 Fairview, did not see any body at 2:30 in the morning. And later at 3:30 in the morning, when he drove back, he found it odd that he saw the homeowner's car, a Ford Edge, parked by the flagpole on the left side of the property. You, the jurors, had the opportunity to go to the property to see how the property looks. And usually, Mr. Brian Albert's car, the Ford Edge, would be parked at the carport, right where the garage is at. There is plenty of space, and Lucky testified that that's where his car was always at. He found it odd that at 3:30 in the morning, the Ford Edge was by the flagpole, which was even something he should have reported. He didn't report because he thought, oh, that is Brian Albert's house. I don't want to get him in trouble. I'll let this one slide. But we are talking about the investigation. This information was found by the defense's investigator, not by any members of the police or the Commonwealth. They did not question Lucky until much after we questioned him. Why weren't they curious to know what the plow driver had to say? Somebody that was present at the scene during the night hours where Mr. O'Keefe was alleged in the snow already. You also heard testimony from Ryan Nagel. Ryan Nagel was behind Karen Reed's SUV the moment that she was at 34 Fairview. She was at 34 Fairview, but she says, I dropped John off. I dropped him off to go into the house to check if the party was still going on, if we were welcome, and I waited for him and he never came out of the house. So I drove away. I was mad. I started texting him, calling him, etc. Now, how is this relevant? Well, Ryan Nagel was with his friend, Dentano, Ricky Dentano. Dentano was the only one not drinking that evening in the car, and he was driving a truck. They parked the truck right behind Karen Reed's SUV. They saw Karen Reed in the SUV. They did not see anybody else in the SUV. They did not see a man in the SUV. They did not see a man in the snow. They did not see a man walking towards the house. You have been to the property. Miss Reed's SUV parked. She says he went into the house. Where else could he have gone if he wasn't in the SUV? So Mr. Dentano's testimony becomes crucial because he's an actual eyewitness present at the time the Commonwealth is alleging this has occurred, or at a very close time. But you know what? Mr. O'Keefe died on January 2022, and the police did not question Mr. Dentano until September 2023. That is almost 2 years later. Why weren't they curious to know what an eyewitness had to say? Another person present, not only at the bar prior to the house party, but also in the house that evening, was Brian Higgins. Brian Higgins is a federal agent. He had a Jeep parked right by the mailbox around the carport area, and he was in the house fraternizing with them. You may recall that Brian Higgins and Miss Reed had been sending flirtatious text messages back and forth. But that evening, when Karen Reed showed up with John O'Keefe at the bar, Karen didn't acknowledge Brian Higgins. She didn't say hi to him. He actually sent her a text, well, and she never responded. Why does this matter? It's simply curious because Brian Higgins is considered a witness, and there are some activities that we did not get an explanation for. Brian Higgins was spotted at the garage in the middle of the night after drinking all night. He went to the police station. We watched the video surveillance here. We don't know exactly what he was doing there in the middle of the night. We watched him making some phone calls. We also heard from Officer Dever, who had given a prior statement, who had given a very specific prior statement. She had said she found it weird that Brian Higgins was at the Sallyport garage where the SUV from the defendant was taken for a wildly long time, given the fact that he was a witness involved in the case. When she testified here, she recanted this statement and said that this was a false memory. But again, the veracity of the witness' statements is for you to decide. The investigation, supervised by Trooper Buchanan, showed that Michael Proctor at the time received no backlash, no correction regarding his words during the text message regarding his conduct. He was actually supported with a thumbs up emoji that Trooper Buchanan provided him. Of course, during his testimony, he said he was just acknowledging the statement. He wasn't liking it. But you can decide for yourself what a thumbs up emoji means these days. And when it was brought up to Trooper Buchanan's attention that Michael Proctor had a previous relationship with the homeowners, the people who lived in the house, Trooper Buchanan said, "Is that going to be an issue for you, Michael Proctor?" Michael Proctor said, "No, it's fine." And that was sufficient for Trooper Buchanan. No further questions were asked about any potential bias, about any potential conflict of interest. So when Trooper Buchanan and Michael Proctor were at the scene, they did not take any pictures of Karen Reed's SUV. They later went to her parents' house to interrogate her. The SUV was outside. They did not take any pictures of the taillight. They allegedly had caused the death of Mr. O'Keefe. The evidence they had was a witness statement from Miss Jennifer McCabe, who you also heard from and who you also get to determine the weight of her testimony. She said, very specific, 3 times, Karen Reed said, "I hit him, I hit him, I hit him." Well, that statement is very contested, and we'll go over what Karen Reed actually said and why. But her statement was sufficient for Michael Proctor and Trooper Buchanan to seal the case, to say this is all we needed, this is the guilty party, and that is what we're going to focus on. They did not investigate any other avenues. They put the case together based on one allegation. So think about this. When you have a small fender bender, a small accident of any sort, one of the first things we do is get outside of the car, say, "Are you okay?" And then what? Call the cops and start taking pictures. The insurance is going to need it. Your mechanic is going to need it. You're going to need it for your records. You need to know what the damage was. So these are 2 experienced troopers at the scene of this alleged incident who did not take any pictures of the car. Why not? When the defense questioned him about evidence logs, Trooper Buchanan responded that it would be redundant. When he was questioned about the exact location that the items were found, he said, well, they were found and the exact location was approximately written in the paper. Well, the evidence log he had at this time just said 34 Fairview, which is a big property, has a backyard, a pool, a house, a garage, a gym, bedrooms, kitchen, outside, front lawn. Where exactly were these other pieces of evidence found? And by the way, as a reminder, these pieces of evidence that we talked about with Trooper Buchanan were not found in the morning of the incident. They were not found by the CERT team who did a methodical search afterwards. They were found by Trooper Michael Proctor and Trooper Buchanan days after the incident. Where have you ever heard an investigator say that after an incident occurs, they keep driving to the scene every day on their way to work, just hoping that further evidence will present itself? This is another part that the Commonwealth has heavily relied on while presenting their case to you. There were 47 pieces of taillight found in the snow, not during the incident, not at the time Mr. O'Keefe was found. There was a hat, there was a shoe, there was a glass. Let's remind ourselves, the only evidence collected at the time Mr. O'Keefe was found, were blood stains in the snow and a drinking glass. And that drinking glass could have come from the house. It was a party the evening before, but nobody was questioned. Another piece of evidence that is interesting during the investigation is the fact that the Ring app from Mr. O'Keefe's phone was opened before it was in the forensic department. Who opened it? What did they do to it? Did they delete anything? I guess we'll never know. And if you think it's far-fetched to suggest that, let's remember the facts. Trooper Buchanan testified here that when talking to Brian Higgins, a federal agent, he gave him a heads up. He said, listen, we're going to go through your phone. You better provide to us the same information that is on the other person's phone. Because if you want to keep your integrity as an officer, you must provide us this information. Now, where have you heard that during an investigation, a police officer will give anybody a heads up about what they're going to look for? That is the opposite of an investigation. That is guidance to what they want him to provide him. And did Brian Higgins provide his entire phone records? No. He extracted the parts that he found pertinent to the case, and that's what he provided to Trooper Buchanan. And Trooper Buchanan was satisfied with that. So the facts, the evidence has shown you that Michael Proctor, the lead investigator, confirmed that the homeowner would not catch any shit because he was a Boston police officer. All the evidence also showed you that Trooper Buchanan, his supervisor, not only didn't admonish him on any of his behavior, but also guided another witness in the case, a federal officer, of what he would look for in his phone. So let's switch gears a little bit. Let's talk about the charges. Ms. Reed is being charged with 3 counts. And for any of the counts to be considered, the jury has to have a conviction that the Commonwealth has presented you with sufficient evidence and facts that prove beyond a reasonable doubt that Ms. Reed has caused the death of Mr. O'Keefe by driving her SUV. In the beginning of this case, we have told you there was no collision. There was no SUV hitting Mr. O'Keefe. We showed you through expert testimony, through several tests, through medical testimony, that the injuries simply do not match a collision. But for any of the charges to be considered, that would have to have been proved by the Commonwealth. So here's the first charge: that the defendant did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the 2nd degree and not in the 1st degree. So on the first count alone, these are the questions you have to ask yourself. Did the Commonwealth prove that John O'Keefe has died? Did the Commonwealth prove that the SUV caused his death? Did the Commonwealth prove Ms. Reed was driving the SUV? And all together, all 4 must be found. Did the Commonwealth prove that Ms. Reed intended all of the above to happen? The jury must find that the Commonwealth has proven all of these considerations beyond a reasonable doubt. And if they have not proven all of them together to you, you must vote not guilty on count 1. So how do we define reasonable doubt? You have heard during the jury instruction, what the judge read to you. And I just want to emphasize one thing. It is not a probability. It's not even a strong probability. Well, it's possible this happened, or wouldn't it be possible that he did get hit by an SUV but didn't have any bruises? Wouldn't it be possible that he did get hit by an SUV but didn't have any broken bones? Well, these are the questions we heard from Mr. Brennan, but we're not talking about possibilities here. We're not talking about probabilities here. We're talking about proof beyond a reasonable doubt. So it is not enough to show a probability that the defendant is more likely to be guilty than not guilty. That is just not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by beyond a reasonable doubt. So we move to count 2, the second charge, that she did operate a motor vehicle upon a way or in a place in which the public has a right of access, or upon a way in a place to which the members have public access, and invitees and licensees with a percentage by weight of alcohol in her blood of 8/100 or greater, or while under the influence of intoxicating liquor, and did so operating said motor vehicle so that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described, did cause the death of another person. So again, the second charge asks you to believe that Ms. Reed not only caused the death, but she caused the death using her SUV. Again, if there is no collision proven to you by the Commonwealth beyond a reasonable doubt, this charge is not applicable. Here are the questions that you must answer and may guide you during this count. Was Ms. Reed operating a motor vehicle on a public road? Yes. Was Ms. Reed intoxicated while operating the motor vehicle with a BAC above 8/100? Did Ms. Reed do so that the lives and safety to the public might be endangered? In addition to the above, did Ms. Reed display wanton and reckless conduct so described and cause the death of Mr. Keefe with her SUV? In order for all of the above to be met, the Commonwealth was required to show proof beyond a reasonable doubt that Mr. Keefe's death resulted from a collision with Ms. Reed's SUV. If any of the jury has questions, has doubts, has other probabilities in mind, has other possibilities, well, maybe this is what happened, maybe that's what happened, you must vote not guilty on count 2. So now we move to count 3, that the defendant did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, did go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to Mr. Keefe, such injuries having resulted in the death of said person in violation with the statute listed. So here are the questions that may assist you in considering this count. Was Ms. Reed operating a motor vehicle on a public road? Did Ms. Reed cause the death of Mr. Keefe with her SUV? Did Ms. Reed leave the scene after knowing she caused injury or death to Mr. Keefe? Did Ms. Reed leave the scene without stopping to provide information in order to avoid prosecution or evade apprehension after knowingly colliding with Mr. Keefe? All of the above questions have to be yes, 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 yes to consider her guilty. If any of the above questions are no, you must find her not guilty on count number 3. Again, if there is no collision proven by the Commonwealth beyond a reasonable doubt of how Mr. Keefe would have incurred the injuries he did and not incurred other injuries consistent with a car collision, then none of the counts can be considered. You must find her not guilty on all of the counts. And although it wasn't our burden, our responsibility to bring a case or to bring proof, we decided we wanted to show you without any doubt that the collision simply didn't occur. There was no collision. The burden to prove a collision was on the Commonwealth. That was their responsibility. And this is what they relied heavily on. They brought you several videos of Ms. Reed's statements during a TV interview. They also relied on the pieces of taillight, the hat, the shoe, the other items found on the snow days after Mr. Keefe was found. Lastly, you also heard from their experts, Shannon Burgess, Dr. Welcher, and other witnesses who presented their testimony here. So I will address the first item, this statement. Did I hit him? Could I have hit him? I hit him. You have heard this statement in different forms from different witnesses, and I want to bring something to light here. On January 2022, not only a tragic incident occurred, resulting in the death of a respected police officer, Mr. John O'Keefe, but also Karen Reed's life changed forever. That day, when she was desperately screaming, in the morning she found her boyfriend, who she had a lovely evening with. We saw the video surveillance. We heard from her friend, Mrs. Kalakithis, that came in and testified they were very affectionate towards one another. She's seen in the scene screaming. What happened? What could have happened? She demonstrated panic, chaotic behavior. And you may even recall when Dr. Russell came to testify about the patterns in the arm of the victim being similar to a dog attack. You may remember that after years of her experience, she said, it is very common for people to start blaming themselves, to start asking questions. Did I do it? What happened? Now think about this. Someone who was questioning what happened to him. If you found a loved one and you're just trying to figure out what happened and your head is all over the place, she drove, that's the last time she saw him. It's not far-fetched for any of us to question, did I hit him? What could have happened? Did a plow hit him? Could I have clipped him on the knee? She was desperately trying to figure out what happened. Not only that, but Dr. Russell confirmed she was experiencing trauma, and some traumas can last for days, for months, and even years. Not only that, but that day, Miss Reed lost her livelihood. She had to stop working, she had to hire a defense team, and she had to spend all of her savings, all of her time, countless sleepless nights going over the possibilities that had occurred, what she was enduring now, how she could defend herself, how she could put on a case to show she had nothing to do with Mr. Keefe's death. This consumed her health, her stress level went through the roof, and after going through this tremendous stress through the past 4 years, she decided to tell a little bit of her story. She decided to give an interview, and this is what the Commonwealth clipped and has shown you very specific little parts, without, of course, the big picture, without, of course, the context. But we're not here denying anything Miss Reed said. We're just showing you a different perspective. Yeah, sure, she might have said in a clip Did I hit him? Could I have hit him? But they didn't really address all the other things she was questioning that could have happened to him that night. Now think about a person who actually has the intention of murdering someone. Would they be hanging out with that person the night before, kissing and hugging? Would they be telling everybody, the police, the EMT, their friends, well, maybe I did it? That just doesn't make common sense. And this is what the Commonwealth has relied upon so heavily to say this is the proof beyond a reasonable doubt. Well, we brought a case too. So you get to decide which case was stronger for you. So the Commonwealth claims that Miss Reed reversed her SUV approximately 64 feet at around 24 miles per hour around 12:32 a.m. on January 22, and that caused Mr. O'Keefe's arm to be shattered by pieces of tail light in a very specific pattern, rotate, fall backwards, hit his head, and that's how he died. So let's break this possibility down. The Commonwealth expert, Dr. Welcher, testified here, and the test he conducted was the following. He dressed as the victim. He held a glass. He's the same height as the victim, approximately the same weight. An SUV with somebody else driving reversed into him at a very low speed, and the height of the taillight was the same as his arm. He showed us that by putting blue paint on the taillight and his arm. His conclusion was the height was consistent with Mr. O'Keefe being hit by an SUV. Is that proof beyond a reasonable doubt? This is the only test he conducted. He came into this test with one result in mind. How can I show this happened? How can I show this happened? He also said, we don't know exactly where he was struck. And he also said, yes, the SUV was driving at low mileage because I didn't want the SUV to hit me at 24 miles an hour. We heard from another Commonwealth expert, Shannon Burgess, the one with the questionable bachelor's degree, and he's the one that analyzed the timestamps. He's the one that translated the timestamps that were showing the SUV and analyzed that according to the phone data, and he testified that the incident occurred at 12:32 a.m. When the defense brought in the expert from ARCR, Dr. Wolf, a biomechanical engineer, he was focused on testing the damage of the taillight. And he created different tests at different speeds. He demonstrated through video, through his presentation, the different tests he made with an arm to show which speed would be required for that type of damage to the tail light. Dr. Wolf's conclusion was that the tail light damage was not consistent with the allegations, that in order to shatter the tail lights, that in order to shatter Ms. Reed's tail lights, the speed would be much higher than what the Commonwealth was alleging. They tested it at 24 miles per hour. There was some damage, but nothing like all the outer damage, the interior damage that was demonstrated in Ms. Reed's taillight afterwards. So Dr. Wolf's conclusion is that the damage to the taillight is not consistent with an arm hitting the taillight. So Dr. Wolf confirmed our statement that there was no collision in this case, because scientifically speaking, after tests, after looking at the force required, the speed required, after demonstrating that through video, the force required to cause the damage to the tail light was simply much higher than what the Commonwealth was alleging was found at Ms. Reed's SUV. After looking at the tail light, we also looked at the injuries. Has the Commonwealth proven to you, the jury, beyond a reasonable doubt, that the injuries that were shown on Mr. O'Keefe's arm, his eye laceration, and the back of the head, that those injuries were definitely caused by an SUV, by a car collision? Well, the medical examiner herself, who testified for the Commonwealth, could not conclude that. You heard from Dr. Scoribello, there are different causes of death and different manners of death. Manners of death could be natural, homicide, suicide, accident, undetermined. On this case, after looking at all the evidence, including Ms. Reed's statements, did I hit him? Could I have hit him? She could not determine this as a homicide. Also, remember, Michael Proctor was talking to his police buddies about this doctor, saying, you should have gone there. You should have secured the homicide finding. How is this a fair, unbiased investigation if the lead investigator shows through his own words that he believes it has an influence on the determination the medical examiner can come up with? Now, one thing that all the doctors, all the Commonwealth experts and the defense experts agreed with is that the cause of death was a blunt impact injury to the back of Mr. O'Keefe's head. So it was a trauma. It was a blunt impact. And a blunt impact to the back of the head could be caused by many different things. Dr. Scoribello also found that another cause of death was hypothermia. This was contested after by other experts, but it is again for you, the jury, to decide which witness statements you're going to give weight to and how much, and which witness statements you're just going to disregard. It is important to note that Dr. Scoribello also testified that there was no evidence of impact sight on Mr. O'Keefe's body when she examined his body. A car hitting him would usually cause bones to break, or bruises, especially if he was holding a glass and the bones to the hand are very fragile. She testified the eyelid laceration could not have been caused by him falling backwards and hitting his head, like the Commonwealth is alleging. She said, when the defense questioned her, could it have been a punch? She said, yes, that is a possibility. And she also testified that there were no lower extremity injuries, which would be expected in a car collision. So here again are the text messages from the lead investigator to remind you that he apparently believed he had some influence, or his other police officer friends believed that they could make the medical examiner provide a specific determination. Rookie move, not meeting with the ME and getting their homicide determination. And then Michael Proctor says at the end, of course it's undetermined. She is a whack job. Honor and integrity, no bias. How can the defense question this investigation? How can the defense question the evidence found afterwards? Where does the defense possibly come up with such a theory? We just have questions, unanswered questions that we believe Mr. Keefe deserved. We believe his investigation showed misconduct, disregard, and simply a lack of respect. We believed Mr. Keefe deserved better. Through the evidence, we showed you guys how there are many other possible explanations for what could have happened to Mr. Keefe that evening. We showed you other possibilities that would be more plausible, more consistent with his physical injuries. You heard from Dr. Russell, who had an extensive resume. She was once a police officer, a forensic pathologist, a dog bite expert, an emergency physician with many years of experience in the ER. The hospital she worked at was one of the biggest hospitals in California, right next to a highway. She saw several car accidents. She saw a lot of dog bite wounds because she also worked for the prison department. Now, when she testified, she talked about the patterns, the injuries shown on Mr. Keefe's right arm, and that they were consistent with a dog bite. So the question we asked, was there a dog around? Where's the dog? What happened to the dog? Could a dog have attacked John? Could a dog have jumped onto him and then made him fall backwards into a blunt object? Was that possible? Did the police officer who lived at the house not want to get any involvement and just put his body outside? His car was right next to the flagpole. Was this a possibility? Was this introduced into evidence through the testimony of Lucky, the plow driver who saw his car there at 3:30 in the morning? Well, not only that was part of the testimony, but the dog was given away right after the incident. None of the witnesses actually confirmed the dog was there the next morning. You heard from Trooper Buchanan about the dog, a German Shepherd, who after being rehomed was renamed, who had previous records of animal attacks. So for us, there are just too many questions that weren't asked during the investigation process. Could there have been a fight? The injury he sustained, the eye laceration is consistent with a punch. Could there have been a dog attack? The injuries in his arm are consistent with an animal attack. You have heard from Dr. Laposada and Dr. Russell on that. You have heard from Dr. Ranchler from ARCA that his injuries are simply not consistent with a car collision. Over and over, the defense has provided you witnesses, tests, experiments that show these injuries were simply not consistent with a car collision. We also have the technology evidence in this case, the Apple Health data. Let's remember a little bit of Trooper Guarino's testimony here. Mr. Guarino testified that Mr. Keefe's Apple Health data registers him taking steps and going up flights of stairs around 12:24 a.m. Again, the Commonwealth is alleging Mrs. Reed reversed her SUV at 12:32 a.m. outside, and that caused the death of Mr. Keefe. But at 12:24 a.m., he's going up a flight of stairs. And guess where there's stairs? 34 Fairview, the house, has stairs. Mrs. Reed connected her phone. Her Wi-Fi data shows she was connected to the house, to Mr. Keefe's house, at 12:36 a.m. It's at least 7 minutes to drive from 34 Fairview to John O'Keefe's house. But that night, there was a heavy snowstorm. So probably it would have taken much longer than 7 minutes. Even the 7 minutes wouldn't be sufficient for her to hit him at 12:32 and be at the house at 12:36. Her Wi-Fi connection supports that. That is in evidence. That is a fact. When Shannon Burgess testified for the Commonwealth, he explained he changed his report after he reviewed the experts from the defense's reports. Now, his report is very crucial because he's the one giving the opinion that this incident occurred at 12:32 a.m. Even after he changed his report, that doesn't really help their case because Miss Reed was at John O'Keefe's house at 12:36 a.m. And that is what the phone records actually confirm. So we've talked about the collision. We talked about the injuries. We talked about the phone data. You have been to 34 Fairview. You have seen how small the front lawn is. You have seen the distance between the flagpole, the carport. You have seen the mailbox where Brian Higgins' Jeep would have been parked. You had the carport where Brian Albert's Ford Edge was. Other cars were there. You had where the truck was when Ryan Eagle parked behind Miss Reed, and the approximate location the SUV was claimed to be at, based on witness statements, such as Ryan Eagle, who saw the SUV there. Now, the claim is that Miss Reed reversed approximately 64 feet. A 60 feet truck looks like this one on the slide. To give you another idea of 60 feet, that would be equivalent to 4 sedans. So with the SUV being there, where this slide is portraying the SUV to be, she would have reversed at 24 miles per hour. That is pretty fast. About all the way almost into the house or maybe into the trees, ran him over. Nobody saw a thing. Nobody heard a thing. And there were many people in the house. They were having a celebration for Brian Albert's son. So they had his friends there. And they also had a lot of other adults that were at the bar and then went to the house. There were at least 12 people there present. At the time, the Commonwealth is alleging this incident occurred. And nobody heard a thing or saw a thing. Especially, nobody saw a body on the snow. So the evidence that we, the defense team, provided is overwhelming. The evidence, the tests, the testimonies, they all support that there was no collision. You have heard from our last witness, Dr. Ranchler, a renowned biomechanical engineer who testified for several hours. We went through his tests, we went through his opinions, we went through his background. And what did Mr. Brennan do? During cross-examination, instead of examining him on the facts, on the tests, he focused a large part of his cross-examination with personal attacks, innuendos, insinuating that there was something wrong with him having a ham sandwich for the defense after testifying. When you don't have the facts, you attack the person. So jury, we ask you, when you look at the form, the jury verdicts form, and you see counts 1, 2, and 3, just remember, for any of those counts to be considered, the Commonwealth should have proven to you that Mr. Keefe's death was caused by an SUV. And we believe that we showed you enough evidence, enough supporting documentation, other very real possibilities and alternatives to cause a lot of doubt. Not only that, we believe the investigation was poor. It showed bias. We believe that from day one, there was a demonstration of a cop protecting another cop, of a tight group, of some type of code. We believe that Ms. Reed was considered an outsider and she was going to take the fall. We believe that it's not far-fetched to insinuate something odd happened at the Sallyport garage. Even one of their own officers had a statement stating that. Wildly long time. I found it weird. She recanted that statement here. You remember her, Officer Dever, but it is not far-fetched. None of the 47 pieces of taillights, the hats, the shoe, none of it was found by any of the first responders, of the first police officers on the scene of the CERT team. They were found by 2 people, Michael Proctor and Trooper Yuri Buchanan, who you have gotten to know here a little bit. So again, jury, it is on you to weigh all the evidence and to decide who are you going to give weight to and who are you going to disregard. So again, we thank you so much for your service and we ask you to please find Ms. Reed not guilty on all 3 charges. Thank you. Thank you for watching, guys. BiancaMMM, your go-to place for mind meditation and motivation to elevate your life and keep you entertained. I'm passionate about exploring the human mind and psychology. And here, we dive into court proceedings, body language analysis, and sprinkle in a bit of humor along the way. You will also find content to boost your personal growth physically and mentally, featuring quick meditation techniques and uplifting messages to kickstart your day. Your support means the world to me. Until next time, take care and stay positive.